Well, we're going to start our webinar. It's at 10 a.m. China time and 10 p.m. our time here in Ithaca, New York. And we will certainly make this recording available to those of us who can't join the live event. So thank you so much for being here. And it's a real honor, as always, to present before our audience, and especially our friends across the ocean. So I'm going to start the presentation and with some introductory remarks also. First, I want to start off by thanking and introducing my colleague, Chris Moe, who will help us with translations this evening.
Yes.
We're very lucky to have Chris as a member of our team. She's a lawyer trained in China, and she has a US LLM degree from my alma mater, Cornell Law School. And we're very lucky to have her. She's a wonderful part of our team. Thank you, Chris.
Thank you, Carolyn.
Great. So let us get started. So we're going to be talking about EB-5 source of funds under the Reform and Integrity Act of 2022, the new EB-5 law that passed in 2022, March of 2022, and also share EB-5 updates. I've been practicing in the EB-5 space for almost 20 years, and all of my visits to China, all of my presentations and meetings, our friends and partners and investors in China want to know what's going on in the United States. What is USCIS thinking? What are they concerned about? What are they looking for when it comes to EB-5 cases? So I'm going to try to be that connection between what's happening on the US side in the EB-5 world and connect it with what's happening with EB-5 in China. Okay. Chris, do you want to maybe translate that real quick?
Oh yeah, yeah, just所以就是 Karen 就简单介绍一下他之前20年在这个EB-5 领域的这些一些经历，以及他也之前在疫情之前，几乎每年都是要来2到3次中国的，然后参加一些展会啊什么，所以和中国这边不管是客户啊还是 agent 啊，我们都有非常密切的一些交流，然后也非常明白这个 RIA 就是新政出来之后，大家对于 EB-5 的这些一些新的法规法条有很多的疑问，所以我们这次就选择了就是大家疑问最多的一块，就是 source of funds 资金来源，然后来给大家做一些新的一些解释，以及新政下面一些新的信息。
Thank you. All right. So advance this slide. Okay. So today we're going to be talking about the source of funds under the RIA and share some updates. Okay, so we're a law firm, so I have to state this disclaimer. This presentation is informational only. We're not giving legal advice here. There's no attorney-client relationship that's created. That's only created by a written engagement letter between Carolyn Lee Pllc, our law firm, and a client. So this content may be promotional. It could be deemed attorney advertising also. So please keep that in mind. And timeframes and estimates that we talk about here really that's what they are. They're estimates, and they're going to vary, pretty widely. So please keep all of that in mind. All right, I'm just going to move right along. Okay, so we're going to talk a little bit about our firm. We're going to cover some of the content that we went over in a presentation some weeks ago, and we received very positive feedback from that presentation. So we're going to recap some of that, please, if you have any questions, please feel free to ask them at the end of the presentation, or really any time. And even after the presentation is over, we will have our WeChat IDs at the end. So please, we want to hear from you and what your questions and concerns are. So we'll talk about visa set-asides. We're going to talk about priority processing a little bit. We're going to talk about concurrent filings, concurrent adjustment of status filings. We're going to talk about investor source of funds, the basics. We'll touch on some common questions, source of funds common questions. And we're going to close with the EB-5 updates. And then we'll have Q&A at the end. Well, so I've got to start with a little bit about myself and our firm. And ton of experience, a lot of experience, many, many years in EB-5 in immigration, in leadership positions. I'm very, very grateful for that. Chair of EB-5 committee for AILA, American Immigration Lawyers Association, and other leadership roles. I think that what's important, what makes me stand out, I guess, and what makes me and our practice different is really the understanding of the new law of RIA. Number one, we were right there in the drafting of the new law. So I've written parts of it as well, especially relating to investor protections, and involved in EB-5 law since 2012. So I know this law very, very, very well. It's also important to know USCIS, to know the agency. And I think it's very important to have respect for USCIS. USCIS has a very, very hard job. It is dealing with many, many, many applications every year. And some of them are very high quality, but most of the cases that they receive are difficult for them to manage. And they have to figure out, well, you know, which cases are real, which cases are not, and apply the law. With EB-5, it's even more difficult for USCIS because EB-5 is very complex. It's got a lot of business elements to it, and USCIS examiners don't have that much training to make it easier for them to work through EB-5 cases. And then on top of that, we have, you know, new law. It's very, very extensive. It's 100 pages of new immigration law. So this is a lot to ask of USCIS. So putting oneself, you know, putting myself in USCIS's shoes, and also experiencing the mindset, if you will, over the last 20 years in how the agency and the individuals and the leadership looks at EB-5 has given me a feeling. It's a feeling, it's an intuition about how USCIS examiners and the agency will feel about questions that we get from clients and partners. So I think that is very, very valuable. The third thing about us as a law firm, is our commitment to Chinese investors and the China market and our friends and collaborators in China. I was a partner at another law firm for 16 years, and I started Carolyn Lee Pllc in 2019. And many people asked me if that was really a smart thing to do, because in 2019, the China market for EB-5 was almost non-existent. But one of the first things I did in 2019 was to visit China as a founder of my new firm, because I wanted, first of all, to say thank you for an incredible career in EB-5. I made my career representing Chinese investors, thousands of Chinese investors. So I wanted to say thank you, and also to say EB-5 is going to come back. There's no question. I didn't doubt it for a minute. But when I went to China in 2019, I will say I experienced that there was this, sense of, it was a sense of deflation, kind of a letdown. And I think people had the right to feel that way. I'm very, very proud and happy that I was a part of bringing EB-5 back to China. So this is really about relationship and showing you all how important this relationship is to me and to my team and to my firm. It's a lot. I'm not going to ask Chris to translate that. Okay, so this is the sort of the promotional part. This is about my firm, and I'm very, very proud to say that we have an incredible team of professionals, of legal professionals who work at the very highest level of integrity, of caring for our clients and for each other. Very, very proud of that. And we know what we're doing. We don't do other kinds of US immigration cases. We only do investment immigration. So this is what we specialize in doing. So we work at a very, very high level in EB-5. So one day I hope you'll meet all of us, the entire team, and I think you'll love them as much as I do. So it's about the people, it's about the heart, but it's also about the tech. It's about the technology. Everybody knows we have changes, rapid changes, important changes in technology. And it is absolutely in the DNA of our firm to capture the technologies and to utilize them to the best that they can offer for our practice and our clients. So for us, it's two things, really. It's using the platforms that everybody has. Everybody has Office 365, Microsoft, but using that platform in unique ways that really uses the most of what that technology that everybody uses has to offer. And I think we do that. And the second piece of it is our proprietary tech platform, CFlow, that we continue to work with every day, many hours, all of us. And we continue to develop it with our incredible development team. And it's my dream come true in my 20 years of immigration. It has a web platform for our clients and partners to interact with and to feed us information about a case. And it has the team platform, we call it the admin platform, where we can take in that information, use it, rearrange it, proof it, check it, and give our clients and partners feedback. And that information feeds into our work product in an efficient way. That is what I've always wanted, and it is what we have, and it is what we're continuing to develop, and it's C-Flow. So technology is important, and communication. Communication is important. Timely communication. We know that this is important to you. Timely communication, substantive communication, meaning it's real. What the responses that you get from me and my team are real. It answers the question with understanding, with expertise. Innovation, we're very committed to staying very close, not only to developing our own technology, but to what the industry is providing the world in terms of AI, artificial intelligence, and automation. Okay, so now let's talk EB-5. Visa set-asides. This is from my last presentation. And obviously, this is where the action is in terms of the big changes that RIA has brought, the RIA. We used to have TEAs, yes. We had rural TEAs, and we had high unemployment TEAs. Most projects were in high unemployment TEAs. US Congress wanted very much to change how the TEAs worked. They were very unhappy with TEAs, high unemployment area designations, covering, very fancy neighborhoods. So we can't do that anymore. And also, US Congress wanted to put EB-5 money into real rural, real high unemployment areas. That's how they would call it, real high unemployment versus how we used to have high unemployment area maps drawn. So we have 32%, about 3,200 visas every year in EB-5 going to the new TEA categories, the new set-aside categories. 20% goes to rural, low population areas, 10% goes to high unemployment, and 2% goes to a new category of infrastructure. And I do believe we will have infrastructure projects coming online, I think soon. So what does this break down in terms of the numbers? It breaks down into about 2,000 visas annually in rural, 994 visas, about 1,000, 10% of the 10,000 total in EB-5 in high unemployment, and 2% or about 200 in infrastructure every year. Now, if you've been doing EB-5 at all, you know that these are not big numbers. These are the numbers every year that we get under RIA. Okay, now we have more than these numbers this year in 2023, okay? 2023, because of carryover. This means that all the unused set-aside visa numbers, if they are not used in that 1 year, that's okay, because they will carry over to the next year. And that's what happened. RIA passed in 2022. We have 3,200 set-aside visas in 2022, but no one was issued any of those visas. So they all carried over to fiscal year 2023. So this year, based on that, we have double the 3,200. So we have roughly about 6,400 in set-asides. That sounds very nice. And we'll talk more about this. However, we have even more visas this year in 2023 because so many visas were not used worldwide because of COVID. So we had about 180,000 additional visas coming over into employment green card categories overall. EB-5 gets 7% of that. And so that translated into about 14,000 additional EB-5 visas in 2023. And so you split that into 32% for the set-asides. And we have a total of almost 7,000 in rural this year, and about 3,400 in high unemployment, and about 680 in infrastructure. So these numbers sound great, but keep in mind, it's 2023. These numbers are not going to be used, unfortunately, because these numbers will only be used after USCIS approves these EB-5 petitions. And we all know from looking at the processing times and observing the processing times that USCIS is taking several years to decide petitions. So that means these numbers are not going to be used this year. And so there's going to be a carryover again in 2024. We're going to lose the 2022 numbers because the carryover is only for 1 year, but we're going to have carryover from 2023 plus the new numbers from 2024. And we're going to have the COVID numbers carrying over to 2024. So we're going to have about 10,000 again in the set-asides in 2024. Now, that sounds great, but that does not mean that those numbers are all going to be used in 2024. Same problem, USCIS processing time. So what happens when these numbers don't get used in 2024? Thank God they are not all lost. Before RIA, they were gone. Post RIA, the unused set-aside numbers are going to go up to unreserved, to the backlog investors. So if we don't use, let's say we don't use 6,000 of the set-asides in fiscal 2024. In 2025, those unused numbers are going to go toward the backlog. So they will do some good. And that is a great thing. That's wonderful. It's not enough, but it is, those numbers will not be lost. And so that's a good thing. Point number one there. Point number two is that we all have to be very, very careful in our messaging, I believe, on this, because, and investors are much more sophisticated, which is also wonderful. They're asking all the right questions about these numbers because Chinese investors have been burned very badly already with the backlog in now the unreserved category. It's an 8-year backlog. We're all estimating, but it's a long backlog. So yes, these set-asides right now are not reporting a backlog. They're not reporting a backlog because when you look at the visa bulletin every month, when you look at the visa bulletin for June 2023, it's current. There is no cutoff date right now for Chinese investors. But that is misleading, probably. because we know that there has been usage, meaning Chinese investors investing in EB-5. Thank goodness. We don't exactly know how many. We know it's more than we thought. And each investor's dependents will also take down a visa number. So I think we don't know exactly when. My own prediction is 2025 will start to report. The visa bulletin will have a cutoff date. It could be earlier. But for sure, there's no question that there is going to be a backlog for Chinese investors in the set-aside categories, probably soon. So we don't want to be in the position of having, said it's current and, to oversell what that means, because there's just a delay in what the visa bulletin is reporting. That's a lot. Okay, so we have to talk a little bit about concurrent adjustment of status. This is another game changer. Huge change, huge benefit. This is incredible. I think most of us on this webinar knows exactly what this means. It means that EB-5 petition, the I-526E, can be filed at the same time as the adjustment of status application, the I-485, if the investor qualifies for adjustment of status. Now, what that means is important, meaning what makes an investor qualify for adjustment of status. They have to be here in the United States lawfully. They have to be here in non-immigrant status. So if there is an investor who is a parolee, who is here on a humanitarian parole or a TPS or some other way that is not a non-immigrant status, a status with a letter like F, they can't adjust. If they have worked in the United States without authorization for more than 180 days, they cannot adjust. Because adjustment of status is not really a right that applicants have. It's what we call, what USCIS calls, what the law calls, discretionary benefit. It means it's a plus. An applicant doesn't have a right to it. But if you qualify as a matter of discretion, the agency can grant a green card through this process, okay? So that's the nature of the adjustment of status benefit. But if you qualify, if you're eligible, if you're in the United States, and this would be F1 students studying in the US, B1, B2, in very limited circumstances, which I want to talk a little bit more about. If you're maintaining status and a visa is available, this concept is going to be more and more important in the years to come. Visa availability, it means current, that the category is current under the visa bulletin. Set-asides are current right now, but soon they won't be. So the visa availability is going to be a much, much more important concept as we go. So if you're present in the US and you meet these eligibility requirements, then look at the benefits. The investor applies for work authorization, so you don't need an H-1B. You don't need, if your STEM OPT is expiring, you have an EAD work authorization off of the adjustment. Travel permission, which in COVID times was so important because you couldn't renew your visa. So having the advanced parole travel option is a huge benefit. Automatic work authorization. Right now, it's 540 days automatic work authorization if you apply for EAD work authorization renewal before the other one expires. That's temporary, but it'll be 180 days at minimum. That's great. And these benefits continue throughout the adjustment of status application. So you file the adjustment of status concurrently. 2 years from now, there's retrogression. And so even if the 526 is approved, the adjustment can't be approved because there's no visa availability. The investor can continue to apply for EAD and advanced parole renewals. Huge. So big benefits. Caution. So these are cautionary tales, or cautionary points, I should say. The advanced paroles are taking a very, very long time. Quite a few clients are having good experience expediting with our help, and some cases without our help on their own. It's great. So in some cases it's not successful, but the normal process for the travel permission is a long time, like 7, 9+ months. During that entire time, the investors can't leave unless they have an H or L visa. If they have an F student visa or a B visa, if they leave before the advanced parole is approved and in hand, it's abandoned. The whole adjustment is abandoned. It's gone. Not terrible now because you would just reapply perhaps. But when there's no visa availability, this will be huge because investors will not be able to concurrently file. Now, I do want to talk about the B visa a little bit because I'm hearing that, and other EB-5 industry professionals are hearing that there's marketing that says, you can come in visitor status and file for your adjustment. I think this is not wise because the law is that when an investor or when a visitor comes in to the United States, they have to have the visitor's intent, the state of mind. And if they're coming in to apply for a green card, that's not consistent with that state of mind that you need for visitor. So I want to move on, but this is very important. And everybody in the EB-5 ecosystem needs to be very careful about treating the B1, B2 visa in the way that it's intended. It doesn't mean you can't use it this way because, for example, there are people, B visitors, whose extensions have been, with COVID or for health reasons, extensions are, have been renewed on and on and on and on. They clearly have been able to change their minds from the time they came in initially in B a few years ago. So there are definitely cases that can support an adjustment of status after a B1, B2 admission. But the point is that it just can't be sold to be a given that you can just do this, that everybody can. Oops, that bad? Okay, source of funds. Source of funds. So here are the basics. It's 800,000 USD plus the administrative fee for regional centers and other fees. Other fees could be the administrative related to the regional center administrative fee, or it could be related to it's it's administrative fees and costs associated with the investment. So it's a little unclear what other fees encompasses. It could include attorney's fees. So our general recommendation is source the admin fee and attorney's fees as well. So if you take all of that, it's about 900,000 USD to source as being from lawful funds. Tax returns is new under RIA. It's explicitly mentioned. So if possible, we want to get tax returns. If possible, the company, the employer, and the individual or individuals or donors if it's a gift. Income verification evidence, I talk about this all the time because almost all the cases have earned income. Somebody worked and got money and used that money to make the gift or for the investment or to buy something that was sold or mortgaged. So income verification evidence is very important. So it's got to be more, if at all possible, than just an employer letter. You know, we're going to have an employer letter that says, we employed XYZ, such and such period of time, they got paid this much. Great, that's basic. But beyond that, we want company registration for the employer. We want company tax returns if they're available. Company financials, we got to see how the company did. And if that is not available, then we do want something else. We call it second best evidence. This is best evidence. This is direct evidence. If the direct evidence doesn't exist, we want second best, you know, and we'll work with the situation, but the idea is this is important to establish. Gift, especially with so many F1s now taking advantage of concurrent filing and being investors and not worrying about aging out. Gifts are very prevalent. So know that donor identity documents are required. You just need it. Every time there's a gift, we need the donor ID document. And of course, we've got to look at the donor's source of funds and the path of funds to the petitioner, to the investor. So that part is not new. Okay, currency exchanges. Clearly, this is a challenge, not just for China. It's really many, many areas around the world. And we have more to change, more to exchange. So this is a challenge and it's time consuming. So, you know, and there's a lot of uncertainties and unknowns. I think the concept here that could be helpful is it's got to be lawful, of course, and it has to present in a way that an examiner reviewing the documents can feel confident that this is legitimate. And there are many ways really to do that. Okay, so clear summary, I think, is very important. You know, it was important with 500,000. It's very important with 900,000. There's just simply more facts to present. So having a clear summary is important. Flow charts and diagrams. If there is pictures that describe the transactions, I think it's very helpful. I know that I find it helpful. Our team finds it helpful. And I am sure USCIS would find it helpful also. Common questions. Do we always need tax returns? If they're available, yes. If they're not available, then no, they're not available, so we can't produce something that's not available. But if they are available, we definitely want to include them. And it strengthens the case. We've been doing this for a very, very long time. Doesn't matter what jurisdiction. If you have tax returns in a case, it makes the case stronger. What if we don't have documents to prove something because it happened so long ago? You know, like my grandfather bought property 30 years ago. Yeah, that's hard. So this is where the second best evidence concept comes in. Your grandfather is not going to have tax returns. Your grandfather may not have good employment documents. But we can't just say, oh, they don't exist, or oh, they're too old, or you know, we have got to try. We've got to try very, very hard. If it's a loan, what should be stated as the purpose of the loan? Great question. There is no one right answer, and there shouldn't be, because that one right answer is not going to be the right answer for every case. So it has to be truthful. It has to be accurate. But that's a very, within those boundaries, it can be anything that's truthful and accurate. Certainly US immigration works. US immigration purpose, investment purpose, that's truthful and accurate. Family gift, maybe family planning, maybe family investment. So we've seen different kinds of purposes. They can all work from US immigration perspective. We have to assume that it's lawful from the local perspective, that they're compliant with Chinese laws. That's fundamental. From a US CIS standpoint, it's lawful and truthful. We should be good. And if we get a request for evidence, we should be able to defend it because it's truthful and accurate. Can gifts from non-parents be used? Yes. Yes. It is true that gifts have a special section in RIA. So that means we do want to be a little bit, we want to give it a little extra attention than we used to before. But it can be from non-parents, it could be from relatives, it could be from your sister-in-law, it could be from friends. But as always, if it's from a non-family member, you want to explain why is a non-family member making this gift. And if the explanation is truthful and it's, there's good evidence for it, it's perfectly valid. Can unsecured loans be used? Yes. So those of us participating in EB-5 for a long time, we know about the unsecured, we know about the indebtedness, RFEs, noids, and denials, which were wrong on the law. And I always knew that, and always made the argument that eventually won in court, that the investment is cash, it's not a loan to the new commercial enterprise. So as a result of those decisions, it is now the case that unsecured loans, loans that are not secured by a mortgage or other collateral, as long as it's lawful and valid, can be the basis for a cash investment of EB-5. So I personally, my intuition, my feeling is that this is still a tricky area. We've got to treat it with respect. It's new-ish. But it is, unsecured loans are lawful. How many years financials should be provided? Is there a magic number? Is it 3, 5, 7? The financials, if available, should be provided covering the relevant time period. So if it's all about, dividend paid to an investor in 2019, well, we should have financials for that company that support the dividend payments in 2019. So it means 2019, 2018, probably, maybe 2017, as far back as are available and are helpful to prove the point that in 2019, the company was positioned to make this distribution of dividends to the investor. So I've said this for many, many years in teaching lawyers and other professionals about EB-5 source of funds. Number one, what are the rules? Of course, what is the law? But number two, what is logical? Being guided by our respectful sense of the USCIS examiner. If I were a USCIS examiner looking at this case, what would I want? And I find that perspective to be very, very helpful. Okay. All right, so now EB-5 updates. So we put them here. We just are talking about the most recent ones, okay? Going back in time from the most recent. So May 15, just about a month ago, USCIS started accepting only the March 15, 2023 edition of the 526E form. If it's the 2022 edition, the edition is on the bottom left of the form, USCIS will reject that form. So we want to get this right. April 25th, a couple of months ago, USCIS held a stakeholder engagement. Now, this is a link to a webinar that we had with respected EB-5 industry leaders. And I think this was a very good discussion. So I invite you to check that out from our website. This stakeholder engagement was about 3 topics: regional center operations, the sustainment period, and the 956K. But we didn't talk about all 3. We talked a lot about the 956K, which is the form that promoters have to complete under RIA, promoters and migration agents. But we did not talk about regional center operations in the sustainment period. And so that was puzzling to most people because they were supposed to talk about those 2 other topics. Okay, March, USCIS discontinues the $85 biometrics fees with the 526E. So we're starting to get a lot of $85 biometrics fee refunds from the government. So we're going to have to figure out how best to deal with this, distribute them back to the investor, have that conversation. Okay. March 1, 2023, USCIS announces it will begin collecting the integrity fee from regional centers. This is the $20,000 or the $10,000 fee that USCIS is going to collect every year from approved regional centers. So there's a little bit of a controversy here in interpreting the new law. Who needs to pay the integrity fee? Okay. So this is kind of outside what we're talking about today, but it is controversial. On February 14th, I had some questions about this. USCIS, this is Valentine's Day, by the way, in the United States, is the day of love. USCIS issues new favorable policy. So this link is to FAQs on our website about age outs, about Child Status Protection Act, CSPA, and age out. It's fairly complicated because CSPA is a complicated law, but in short, it stops the aging earlier. You know, the child is going to continue to get older and older and older. And if the child is older than 21, then they age out. They can't be included with the parent, which has happened to many children in the backlog. This policy is favorable because under it, in some cases, the time frame for the child's aging will stop earlier. So that means some kids who would have been over 21 under the old policy will still be under 21 under the new policy. And it's generous because if the case was denied based on age out, or if there was a child that was deemed to have aged out and the case denied as a result, the adjustment for that child denied as a result, you can file a motion to reopen that denial and USCIS will consider it. And I think based on this policy, you know, unless there's another problem, it feels like USCIS will want to reopen that adjustment denial and possibly grant it, which would be wonderful. And I'm really looking forward to hearing some good stories about that. So I want to thank you again. Thank you to my good friends over the years. I can't thank you enough. I adore you. And new friends, and we'll keep doing our very, very, very best for our clients and for our friends, and keeping this connection that is so important to us going strong. Okay, so we did go over an hour, but if there are questions, please post your question. Now, we can see you, but you can't, no one else can see you. So please feel free to post your questions in the Q&A. Don't be shy. And we will read the Q&A and answer your questions. And it's also okay if you want to ask them privately. We have our WeChat IDs right down here. Let me go back up here to some common questions and also our basic points. Let's come back here. And we can linger a little bit on each of these. Tax returns, you know, a common question we get is, you know, well, we didn't have tax return, you know, we didn't have to file tax returns, or, you know, the taxes only started to be required certain time ago, and our transaction happens before then. What do we do? So far, there is the agency recognizes that the tax returns are have not always been required. So as long as we can, as long as there's a reason that we can provide, and for the absence of something like tax returns, we can, I'm knocking my head for good luck. I think we can rely on the examiner being reasonable, While we're talking about the unknown, we don't know what USCIS is going to ultimately say. We have to be honest and say, yes, it's true. We don't know. We don't know. We're not certain. And we are not going to know for about 2 to 3 years. So I think this is the time when this experience that we have is most important, because until we know, until we get decisions from USCIS, all we have are the law and our intuition, our experience. So we're really, I really are tuning in to that experience and to our sensibility about what the agency is going to want, what it's looking for in this new world of RIA. What if we don't have documentation? I'm just going to check the minute. Okay. What if we don't have documents to prove a fact? Again, this is tough. This can be tough. And what I always say, and I hope this isn't too much about repeating, this is my experience. There is a quality, there is an energy, there is something that is communicated to each other, from me to you, from you to me, from me to a client, from the client to me, from us to the agency. When we prepare a case and we file that case, there's something about that quality that is speaking to that examiner, and they can see it. It comes through. And that's why I do say, in this time when we have so many uncertainties, to show the effort. It's okay if the document doesn't exist. If it doesn't exist, it doesn't exist. But if we know that that is an important piece of information that a reasonable examiner is going to want to have, is going to want to know about, we have to show that we understand, that we respect it, we get it. And we have tried to meet that expectation. And we know that it's not going to be the best evidence because it doesn't exist, but it's going to be the best that we can get. And I'm telling you that I believe that that is communication, and it helps. Okay, so we have a question. Chris, please
Okay,
help us.
Yes. This attendee is asking like for real property loan, mortgage loan, source of funds type. Well, USCIS asked for this real properties authentic mortgage certification. I'm kind of don't understand what is authentic, because it should be authentic.
Yes, absolutely. Yes. Oh, okay. So yes, we don't quite understand the question, so please feel free to elaborate, to say more.
Yes.
But this is a good question, that the way that I understand it. The documents and the facts do have to be as they are. Now, this is, in some respects, it's a background kind of a thing. It's an expectations. There's, you know, it's what works in one context does not work in another context, and vice versa. You have to understand that immigration is looking for inauthentic documents. That's their job. It is 100% their job. And they're good at it. And in fact, you can say they're good at it, and they're also hyper focused on it. Hyper means a little too much sometimes. So we have to understand that. So if there is a difficulty, we cannot sort of go around that difficulty. We have to look at it head on and deal with it. I can tell you too, but you know, thousands of cases I have seen, and many difficult cases, many difficult cases that have been approved because the person on the other side is not unreasonable. We show the difficulty. This is where the good lawyering and the good advising comes in. Some cases are easy, some cases are hard, but it's working through those hard cases that I mean, those cases can be approved as they are. Chris, you want to try to translate that idea?
Yes, yes.
所以 Carolyn 的意思就是说，首先，我们肯定是希望所有的文件以及证明都肯定是真实的，即使他自己本身可能缺乏一些说服力，但是它一定得是真实的，因为我们想要提供给 USCIS 是，就即使它的证明力不是那么的充分，但我们可以尽我们所能去解释，或者说去通过其他的间接证据来去使这个说服力更巩固一下，然后对，这就是 Carolyn 说的一些核心。We can move on to the next question.
Okay, cool. Could you please explain the AOS with B visa? And there's another question about the B visa and AOS. Ooh, okay. So, for the adjustment of status process, as I said, there are some rules. One rule is that you have to be in a valid non-immigrant status. And you have to be maintaining that status. You have to be, you came in a non-immigrant status, like a letter status, B or F or H or L or O, and you are maintaining that status. You're not working without authorization. You're not doing something you're not supposed to. And you have to be admissible. Admissible means no violation of immigration laws, US immigration laws. Now, coming in, so the B, that's adjustment. That's what you have to do. Because remember, adjustment, you don't have a right to it. It's, you know, if you're good, if you follow the rules, then USCIS can give you this favor. And that's the law. It's a discretionary benefit. Now the B is a specific type of visa. It's for visitors, visitors for business, B1, or visitors for tourism, B2. Sometimes a client can have B1 and B2, B1, B2, or B1 or B2. They can only use that visa to come in for that B1 or B2 purpose, and that's it. So we all know I can't come in on a B and work, because working is not authorized by a B. However, I can come in as a B and visit the Disney World, you know, because that's permitted. So it's about, if somebody, it's the issue is what we call preconceived intent. Preconceived intent. The client, the investor, cannot come in to the US with a B visitor's visa that says you can only do these things, with the idea that in fact they are going to come in and they're going to apply for a green card. That they cannot do. They cannot have that. Because if they do have that, let's say I have a B2 visa and I'm coming in tomorrow, and I know I am going to, in 90 days, I'm going to file for my EB-5 green card. I'm going to file for my EB-5, and I'm going to file for my adjustment of status. And that is what I'm going to do. That is going to be problematic, because that investor client has that idea in her head, in my head, that I'm going to do this. And that's problematic. That's the problem, is I can't in my head have the idea that I'm going to do this. Now, if we think about it, this is a very strange rule, really. It's not strange if, you know, I'm coming in with my, 4-year-old, and that's all I'm going to do. I'm going to go to Disney World for a week, and then I'm going to go back home. It's not strange at all. You're totally fine then. But it is strange if, I'm doing a lot of things. I'm a wealthy person. I have visas all around for travel all around the world. I do business all around the world. I have kids studying in the United States. I want to apply for a green card, and I have a lot of things in my head. I don't just want to visit Disney World. And this is very, very real, right? So it isn't that cut and dry. It's not black and white. But that's a good thing. That is a good thing, because it's honest, and I can have that. I can be that person. And we have clients who are that person, who are like, I don't know. I could be doing lots of things, but I am going to come into the United States tomorrow. And because my advisors have advised me correctly, I know that I have got to follow the law and make sure that I can truthfully say that when I come in tomorrow, that my intent is to not abandoned my home in China. I'm coming in for a short, specific purpose. And I'm going to follow the laws. You know, that is what the law requires. All right. There's another question. Okay, so there is a component of the B1, B2 question that I didn't quite get into with all of that, which is the 90-day. Now, the question came in its, you know, in the language was 90-day rule. That actually isn't a rule, and that 90-day concept was in guidance that has since been withdrawn. So what does that mean from a USCIS standpoint? I think it could mean that just because you've waited 90 days, it doesn't mean that you've cleared some hurdle. If I had that preconceived intent, if I knew coming in the next day that I am going to apply for adjustment of status, then even if I wait 90 days, USCIS could still find that I violated the law. So this is not unique, right? Those of us who've been doing this for a long time and working with immigration, there are other areas like abandonment where this kind of, you know, factual inquiry about your head, what's inside your head, goes on. So it isn't new. It is complicated. We have to be very, very careful because, like I said, there is, you know, there's stuff out there, and we can be quite sure that immigration is aware. And if it's not aware, it will be aware and will be looking for these issues of preconceived intent in these facts. I don't have all the answers. And it is also case by case. But I know that my advice when I am asked these questions, I try to be conservative. I try to convey, we've got to be careful about this and take it seriously. All right. We have one more question, and then, respecting everybody's time,
Yes.
we'll resume later.
Mm-hmm. Do you want me to translate the last
Yes,
question?
please do.
Yes, of course. Do you want me to summarize what you just said about BB?
Oh, yes, that would be great.
Of
If you
course,
could try,
I'll be
that would
really
great.
quick. Yeah.
Okay.
So yeah, basically, 所以对于关于 B visa，那么在 B visa 的情况下做 AOS 的情况的话，最主要的其实 Carolyn 想提醒2点。第一点是因为 B visa 它是一个 visitor visa，也就是说你在入境海关的时候，海关肯定是会问你一些问题的嘛。这个时候我们的 client 一定要保证他自己的我们叫 preconceived intention，which is like 就是事先承认的事实，就是我现在是一个 visitor， 我来这里是要去哪里玩 ，let's say like 迪士尼，我要做的其他事和我现在进来没有任何关系，我可能之后要做什么，但是和我目前以一个 visitor 身份进来的这个 intention 没有任何关系，所以这是一定要让客户知道，要提醒客户的，即使我们都知道他可能是待了90天之后要做 AOS， 但是在进来的时候，他一定要有这个清晰的认识，这是一个心理要件。不然的话，可能是一定是会违反这个移民法的。然后第2点就是关于是不是来了90天之后，我们就一定可以转 AOS 就发有 AOS 了呢？就是我们这个其实它是base 在我们做的所有的 case 上面，我们认为90天就是 by experience 90天是能够在用 B1 B2 进来之后90天是能够做 AOS 的，但是 这并不是一个明文规定的条款，且就是我们不可能100%的保证它就一定是可以，只是说大多数情况下它是可以的。所以就总结一下刚才 Carolyn 回答的2个问题。And the last question. So this is basically a case about real property, like a gift by selling real property. So basically, like there's gonna be the 10 years ago, like the father and the mother, the parents and grandparents, 4 of them, using their earned income to buy a real property, and the owner's name on the registration certification is from grandparents. And now the grandparents wants to use the sale of the proceeds and gifted the proceeds to their grandson for EB-5 investment.
Right.
So first, is that doable? And second, how can we explain that 10 years ago, like their earning income, how they get these income to buy the real property, and what documents should we prepare?
Yes, I mean, these facts are completely workable. Yeah, I don't see anything wrong with these facts. So it is a little bit complicated because you have the 4 owners for the property bought 10 years ago. In our experience, one of the complicating things about that kind of a scenario where you have the parents and the child, which is very, very common in China, right? It's common in Asian cultures. We buy things for our parents, or parents buy things for their children. So in a fact like that, what we want to understand, what the examiner wants to understand, is who bought that property. Which, again, culturally, it may not be that easy. You know, my money is your money, my mom's money is my mom's money. Culturally, in America, it's separate. It's more separate. So that's the difficulty. So 4 people are registered owners of that property bought 10 years ago. And when I ask you, well, who bought the property? The client may not be able to really answer that. Well, you know, it's 4 of us, but I put in some money, my husband put in some money, my mother, my dad, my sister contributed because it's our parents. That's the difficulty, is who bought that asset, who bought that house. And then once we figure that out, and it might have to be a bit of like, you know, well, you have to remember, they may not remember, and it probably wasn't that important. It's a family, but that's what we have to figure out. And that's what we have to document. And we work with the facts. We really work with the facts. Sometimes the facts are not that clean. They're not, meaning they're not that easy. And that's okay. So let's just say in that scenario, it is messy. It's real. The family doesn't remember. It's my parents. I use my husband's money. It's my sister. It's our parents. My sister also contributed to it. It's okay. I think that's my approach, is it's okay. And we're going to work with that. Let's say it's 10 years ago. So let's say I'm the daughter. I have good records. I worked for my own company or a big company, and I have good earned income records. But the reality is I didn't pay for all of it. You know, my dad paid for some of it from his employment earnings from an employer that doesn't exist anymore because my dad's retired. You know, it's happened it's okay. We'll work with them. We'll work with the facts as they are, because that's the truth. And if those documents don't exist, or if the investors don't remember, it's okay, because those are real facts. And if USCIS is not happy with real facts, we have a real problem with this program. The problem is not going to be with your investor. It's with the program. Because if the program is forcing investors to make up facts to get the case approved, then that is not a good program. So it's okay. If the facts are messy, meaning difficult, meaning not clear, it is okay because that's life. And we will work with it. We, meaning collectively, we will work with it. Okay, Chris.
Yes，对，就是所以说这样子的情况虽然很复杂，但是也是完全我们是可以做到的。虽然我们要提供的一些背景文件很多，但是在保证它真实的前提之下，我们会尽可能的在 SOF memo 里面写完全清晰且做到说服力，有说服力。提交给 USCIS， 然后具体如果这个问题具体要问到详细到哪些文件的话，我觉得可能如果到真的就是有这个 case， 您可以发邮件给我们，或者说写微信给我们，然后我们这边也会有相关和各种不同的骚骚放相关的 checklist 可以给您参考。对，就是这样。Yep.
Cool. Okay. Well, everybody, thank you so much. Thank you. I'll just open up to our WeChat ID page again. Please feel free if you have questions, let us know. We want to understand what's working, what's not, what is of concern. So we welcome the questions and thank you so much. We're going to try to do these regularly in different formats maybe, so we're experimenting with this communication, so thank you again and we'll be back.
谢谢大家，大家可以加一下我们的微信，然后这个培训的话，我们是计划大概每个月或者如果需求量大的话，可能会每2周做一次这样子的培训。然后也非常欢迎大家接下来继续关注。Thank you.
Thank you, Chris.
Thank you, Carolyn. Thank you, everyone.
Thank you.
Bye. Have a good day.
Bye-bye. Have a great day.